All right. Hello, I hope everyone is having a great Monday. My name is JV Lankildy, and I am the Director of Treks and Conferences with the Harvard Association for Law and Business. Thank you so much to everyone for joining us today, and welcome to the opening event of our 2021 HALB Symposium. At Symposium this year, we're welcoming leaders in business and law to talk about the challenges brought by 2020, namely the COVID-19 pandemic and racial inequities that continue to be prevalent in our communities. In addition to reflections about their work in the past year, we're also discussing with leaders in different industries how they can respond in charting the path forward. For our opening event, we're so honored to hear from Professor Ruth Okediji with Professor Arewa as well. Today, they'll be speaking with us about how corporations influence the direction of legal change and implications for race and human welfare more broadly. Professor Okediji is the Jeremiah Smith Jr. Professor at Law at Harvard Law School and the co-director of the Berkman Klein Center for Internet and Society at Harvard University. In addition to being a renowned scholar in international intellectual property law and a foremost authority on the role of intellectual property in social and economic development, Professor Okediji has advised intergovernmental organizations, regional economic communities, and national governments on a range of matters related to technology, innovation policy, and development. She has widely cited scholarship on IP and development, and her ideas have helped shape national strategies for the implementation of the World Trade Organization's agreement on trade-related aspects of intellectual property rights. She works closely with several UN agencies, research centers, and international organizations on the human development effects of international IP policy, including access to knowledge, access to essential medicines, and issues related to indigenous innovation systems. Professor Okediji was a member of the United States National Academy's Board on Science, Technology, and Policy Committee on the impact of copyright policy on innovation in the digital era, and also served as a chief technical expert and lead negotiator for the delegation of Nigeria to the 2013 World Intellectual Property Organization diplomatic conference to conclude a treaty to facilitate access to published works by visually impaired persons and persons with print disabilities. In 2015, UN Secretary General Ban Ki-moon appointed Professor Okediji to his high-level panel on access to medicines. Also, in 2015, she was recognized by Managing IP as one of the world's 50 most influential people in IP law. She currently serves as co-chair of the National Academies of Science, Engineering, and Medicine Committee focused on improving commercialization of digital products from national labs. Over the course of her career, Professor Okediji has been recognized with numerous teaching, research, and mentoring awards, such as the Stanley V. Kenyon Tenured Professor Award for the Best Tenured Professor, the professor most likely to go beyond the call of duty, the Regent Superior Teaching Award, the Student Bar Association's Outstanding Professor Award, Harvard Law School's Women Law Association Shatter the Ceiling Award, and honoree of International Women's Law Day. Professor Okediji is also the 2019 recipient of the IP3 Award from Public Knowledge, which recognizes significant contributions to the IP field. Also speaking with us today is Professor Arewa, who is joining us from Temple University's Beasley School of Law, where she is the Murray H. Schusterman Professor of Transactional and Business Law. Her scholarship and research covers issues in music, business, private equity, venture capital, technology, copyright, film, and Africana studies. In addition to this research, she is working on 2 books, one touching on technology disruption in Africa, and the other on the global impact of African-American music. At Temple, she teaches courses including business associations, private equity and venture capital, corporate finance, accounting, and mergers and acquisition. Prior to becoming a law professor, Professor Arewa practiced law for nearly a decade, working in legal and business positions at law firms and technology startup companies. She served as chief financial officer and general counsel of a VC firm in Boston. Before becoming a lawyer, she was a visiting lecturer at the Center for Afro-American and African Studies at the University of Michigan, and served as an economic officer in the US Department of State in Washington, DC, and Uruguay. She received an MA and PhD from the University of California at Berkeley, an AM from the University of Michigan, a JD from Harvard Law School, and an AB from Harvard College. Before I hand it off to Professor Okediji to begin, I want to quickly highlight the format of our event. Professor Okediji will provide a keynote address, after which Professor Arewa will then speak with us, sharing her comments. Around 12:45, Professor Okediji and Arewa will then be answering audience questions for the final 15 minutes of the event. So please feel free to submit questions throughout the event via the chat function, and we will get to those questions at that time. Without further ado, Professor Okediji.
Thank you so much, JV, and to the Harvard Association for Law and Business for the opportunity to speak and to deliver this keynote address at this yearly symposium. I'm grateful to all of you for the trust that you have expressed in me, and I hope that in the next 25 minutes or so of my remarks that we will have both a fruitful and I hope productive conversation. My remarks will explore a topic that many have spent quite a bit of time in this past year thinking about: the intersection of race, social well-being, and the soul of the firm. I've deliberately described this talk in the context of the soul of a firm because I believe that the corporate firm, which is endemic throughout the United States and which represents so much of both our prosperity and our values as a country, also is the place where values, contests over those values, and principles for what the unfolding shape of society will look like can be found. And so when we think about social well-being, particularly in what I have referred to as the age of distress, it is important that we begin to look at both the legal and the non-legal constraints within which the firm operates. This has been a year of distress, a year that has been marked by overlapping pandemics, political pandemics, a health pandemic, fiscal pandemics, and racial pandemics. More than at any other time in recent history, Americans have been engaged in discussions about the vision for our society and the laws and institutions that underpin our most central values, if we even know what those are anymore. Most of us are aware that more than half of Latino and nearly half of Black communities in the United States have been economically challenged as a result of the health pandemic, substantially more than 25% or 21% of Caucasian of the Caucasian population. More women reported significant mental health concerns related to COVID-19 and the effect of staying at home to care for children who could not go to school, as compared to men. Most Black and Latino communities have reported mental health challenges overall in far greater numbers than Caucasian communities. And of course, with regard to healthcare providers and state and local officials, all of these have received lower marks from these communities than in others. None of this is really a surprise to many of you. We have embarked in this nation in a season of soul searching around the activism and the explosion of activism that erupted around the racial and economic fault lines that all of these pandemics have revealed. Most notably during the Black Lives Matter protests of last summer and the COVID-19 pandemic now entering its second year, which has regrettably claimed the lives of over 2.6 million people around the world. I think it is no secret, it is no surprise, and it surely is a mark of the need for our coming together as a nation that these pandemics have revealed deep fault lines in our country. The defining health crisis continues to highlight the way in which the entire world is increasingly dependent on the private sector. The role of the firm in resolving, addressing, and sometimes in exacerbating the underlying causes of these various pandemics is going to be the focus of my remarks today. It is these firms, sometimes with private funding, sometimes with government funding, to which we have turned to safeguard public health by developing vaccines, testing methods, and all of the personal equipment personal safety equipment that we relied on during the pandemic. Firms constitute the herald of American life. They are the incubator of American values. But firms also embody the limits of private law. As incubators of these social norms and as political power brokers, firms often embody the uncomfortable synthesis of our democratic demands for accountability, for the welfare of all, as well as our liberal insistence on individualism and economic well-being in executing our private wills. The fragmentation of the American social consensus has left firms in the uncomfortable position of generating rules and practices and positions that can and do exert important influence on the law. Over the last decade or so, corporate social responsibility and sustainability has occupied a prominent place on the global corporate agenda, with an ever increasing number of corporations engaging in responsible and sustainable business practices in an effort to create social and business value, or at least to create the perception that there's less of a gap between business value and social well-being. Specifically, the corporate response within the last year of prolonged crises shatters the idea that corporations exist solely to promote shareholder value. This is, of course, an idea that in academic circles and in business schools has long been on the decline, but I think in the broader society, the role of the firm has become front and center of focus for our understanding of well-being. Major companies, often wary of conflict, especially in these polarized times, have been taking stands on racial injustice and police violence. Additionally, many CEOs see themselves as leaders of the fight against the pandemic. They are the individual leaders that are standing up against anti-vaccination sentiment that's been strong in countries like the US, France, and Russia. And these same CEOs are trying to keep their workers safe. More recently, many have served as vaccine ambassadors, urging employees and the general public to trust in and to take the vaccine. Most of this conduct is, of course, extra-legal. Nothing in the corporate bylaws, nothing in the contractual commitments or employment obligations necessarily compel these actions by CEOs or by firms. But as Justice Holmes famously asserted in his essay, The Path of the Law, the man of the future is the man of statistics and the master of economics. In other words, firms essentially are social legal constructs. They are focused on capital accumulation, and they are focused on the conditions in the market that make this goal possible. And CEOs, as the key agents of firms, have been at the forefront of attempting to bridge this gap, this dissonance between the idea that firms can only make money at the expense of all else and the notion that firms are responsible for the entire well-being of the population. Neither is, of course, the case. Over the course of the next 15 minutes or so, I want to unpack in very short thrift this multi-decades long trend of an effort to fully embed firms into the social fabric and into the set of institutions responsible for the social well-being of the community. I have a number of points that I want to make, and so if you remember nothing else, I want to leave at least 3 main points on the table for further discussion and reflection over the course of the rest of this symposium. First, I want to say that firms cannot be and are not the primary or even the dominant solution of many of the pandemics that we face today, these increasing crises that create distress within our broader community and society. It is instead the failure of a number of social institutions writ large that have precipitated much of the considerations and the failure of economic advancement that we see in Black and brown communities in our society today. the failure of these institutions that support in a generative way values that could strengthen our common legal and economic framework. Second, I want to talk about the absence of principled leadership, not only before pandemics might hit, but in the season after pandemics hit. Oftentimes, principled leadership is like a fire extinguisher. It comes out in the midst of a crisis, but often it is possible to think about firms and think about economic leadership in the context of pre-pandemic, pre-crisis, pre-emergency situations. In other words, there's a possibility that leadership at the right time, with the right values, for the right reasons, might constitute opportunities to ward off future pandemics. And third, I want to highlight the paradox that we see today, a paradox in the rise of legal mechanisms like arbitration, non-disclosure agreements, that at once adversely affect access to justice, but also purportedly expedite the resolution of legal claims. So in today's address, I want to identify at least, or will come about in 4 distinct parts: a brief history of corporate activism and the extent to which current practices deviate from this original model as it emerged. Next, I will examine the extent to which corporate activism is a legal requirement versus something that firms take on in a voluntary fashion. And then third, I'll explore the outcomes of corporate activism on communities and shareholders' bottom line. Finally, I want to make a few comments about the extent to which corporate activism is an essential component of a functional society, and some surprising implications for our values as a society. Professor Arewa, in her remarks, will focus on tech companies, and so I will not go too deeply in any one sector, but I think it is fair to say that one of the principal challenges facing us today is that there are an insufficient number of institutions and people making decisions for a large number of members of our community. It will be helpful to define the terms that I'll be using: corporate social responsibility, corporate social justice, and corporate activism are often used interchangeably to refer to a general trend over the last 50 years or so, in which firms have included social issue marketing, philanthropic efforts, employee volunteer initiatives, diversity and inclusion work to build their brands and to satisfy customers. In other words, corporate social responsibility and corporate social justice, all of these dimensions of corporate activism all feed into the idea that corporate well-being is itself defined in relation to the considerations that the market and that consumers and customers have at the forefront of their minds. I want to acknowledge upfront that structurally, these are different terms, and the differences in these terms and their use in academic discourse in particular is not standardized. But I will proceed under the assumption that at a high level, these terms mean that the companies and the firms that are engaged in corporate social justice or corporate social responsibility are focused on a consideration of what society thinks about the activities of the firm on issues that are polarizing, issues that have effects on minority communities, and issues that speak to the well-being of society as a whole. Social well-being is a term that I use to mean the ability of people to be free from want of basic necessities and to be able to live their lives fully and in pursuit of the things that they view as being essential for their sense of well-being. And of course, I will refer to stakeholders as all non-shareholder constituents of a corporation, including employees, customers, suppliers, and all those in the supply chain, including sometimes government and the general public. Now, I think we must start first with what is a firm? What is the purpose of the firm? A firm, as many of you know, is a commercial enterprise, a company or a corporate firm that buys and sells products or services to consumers with the aim of generating profit or accumulating capital. Formally speaking, a corporation is an abstraction. It's an abstraction to which we assign rights and duties. It exists independently of humans in the sense that it has an indefinite life. But of course, it is human agency that makes the firm possible. The notion of a firm, its legal identity, is extraordinarily useful and widely used as a device for organizing relationships between various people and assets. It's a way that groups of people can pool assets and transfer them to this firm that will act as a single interface with third parties. Of course, firms or corporations are also involved in technologies that facilitate not only employment today, but also the deployment of law enforcement strategies. Being an abstraction rather than a real person means that a corporation is exercised, as I said earlier, through human agency. Humans are involved directly through a chain of corporations, and that human agency, the conditions that shape that agency, must become a much more important consideration of the firm and of those who steward its place in society. Of course, we also know that the firm is governed somewhat in a default manner through shareholders who are elected, and a board of directors who appoint a chief executive officer and other top management who in turn act on behalf of the corporation in day-to-day matters. But when firms fail, as they do, it is this human agency behind them the society excoriates. And when firms succeed, it is the same human agency behind them that society praises. A firm is not the subject and object of much of our attention until they either succeed greatly or fail greatly. And yet, as many of you know as students of law and business, that it is often important that firms reflect the broader social anxieties and concerns for purposes in particular of advancing the well-being of those communities that often are the most marginalized from the mainstream economic life of the nation. In 2019, at a business roundtable, a press statement was issued titled "Statement on the Purpose of a Corporation." And in this statement, companies such as Amazon and JP Morgan Chase and AT&T and many, many more endorsed a move away from shareholder primacy and included that part of the role of the firm is to respond and to make good on its commitment to all stakeholders. In speaking about the statement, Alex Gorski, the chairman and the board of the and chief executive officer of Johnson & Johnson, chair of the Business Roundtable Corporate Governance Committee, said, "This is a statement that better reflects the way corporations can and should operate today. It affirms the essential role corporations can play in improving our society when CEOs are truly committed to meeting the needs of all stakeholders." Since 1978, the Business Roundtable has periodically issued these principles of corporate governance, and each version of the document has endorsed principles of shareholder primacy. But in this new statement, in 2019, you see that it supersedes previous statements. It formalized a dramatic shift in our understanding of the relationship between social well-being and the corporation, and it has, of course, been in evolution for nearly a century. And so at the turn of the century, at the turn of the 20th century, if you had asked, what is the purpose of a corporation? The standard answer would have been to maximize shareholder benefit. But of course, and this is no surprise, that in 1957, Harvard economist Carl Kaysen wrote that business managers should see themselves as responsible to stockholders, employees, customers, the general public, and perhaps more important, the firm as an institution. In other words, there has been over time this tension between the audience for the firm, the stakeholders for the firm, and to whom the firm owes its greatest obligations. Managers were expected to govern the corporation to benefit shareholders, but not as we can see in this most recent statement, not shareholders alone. But of course, American corporations have long won a secure place in the American economy. And many members of the workforce, many employees, including the government, became dependent on the corporate form. And one of the challenges, of course, is the understanding that it is no longer the case that the corporate form can simply take gleeful pride in making money and turning its back on those concerns that affect greater members of the population. As corporate norms began to embrace a more social view of their purpose, the law appeared to follow. For example, the New Jersey Supreme Court held as early as 1956 in a decision called A.P. Smith Manufacturing that its judgment was resting on any benefit that would accrue to the company on the belief that corporations had responsibilities beyond those owed to shareholders. The court held that corporations needed to acknowledge and discharge social as well as private responsibilities as members of the community within which they operate. We also saw this shift with anti-takeover statutes of the 1990s, which was intended to allow corporate boards to take into account non-shareholder constituencies, really employees, when fighting a takeover offer. In the wake of the merger mania of the 1980s, the corporate social responsibility debate shifted slightly. At this time, the controversy focused more on the corporation's responsibility to all of these stakeholders in a way that was so significant that it is often regarded as one of the most significant changes in US corporate law since the New Deal era. Statutes that explicitly permitted directors to consider the effects of their decisions on a variety of non-shareholder interests. With very few exceptions, the statutes really did no more than to authorize director consideration of non-shareholder interests. Rarely was any legislative effort made to provide substantive or procedural standards for applying these laws. So although there was a shift in rhetoric and there was a shift in the way in which there was a accommodation of non-shareholder interests, in reality, the execution of these statutes fell far short. So-called non-monetary factor provisions were also relatively common. They permitted and in some cases required directors to consider a variety of non-price factors in evaluating a proposed acquisition. In particular, most of them allowed directors to fend off a pending takeover bid for an in-state company. Corporate social responsibility increasingly also began to take the form of core business decisions and investment strategies. For example, over the past decade, trustees have come under increasing pressure to consider environmental, social, and governance factors, known as ESG factors, in their investment decisions. Consideration of these factors and concerns moved from the realm of activists into mainstream, starting in the 1970s with the advent of socially responsible investing. SRI, socially responsible investing, emphasized the avoidance of morally questionable investments, not the pursuit of better risk-adjusted returns. SRI funds are thought to have emerged from the instability of the latter part of the 20th century, particularly in response to the Vietnam War. Now, I want to step back and say we might think of this as a struggle over moral delegation. Should private actors be morally responsible for the conditions from which they seek to profit? If so, what principles might inform those considerations? Recall during the late 1970s and 1980s, South Africa's apartheid policies, which really placed socially responsible investment into the spotlight as activists called for complete divestment of firms doing business in South Africa. Calls for ESG investment decisions have continued in the form of divesting from fossil fuel, divesting from tobacco or firearm companies or prisons, or otherwise accounting for environmental or social costs in making these investment decisions. Now, it's important to note that post-apartheid fiduciary law governing socially responsible investing was mostly silent until the 1990s, when between 1995 and 2005, numerous socially responsible investment funds were launched and their assets under management increased substantially. One estimate indicates that these funds grew from 12 billion to 179 billion, and that growth has continued with net inflows from the first half of 2019 exceeding full year net inflows from 2018 by more than $3 billion. Corporate governance was more explicitly incorporated into investment strategies. And these SRI fund managers asserted that SRI funds could be both morally and financially superior to other funds, offering lower risks and higher returns. In other words, SRI funds began the hard work of incorporating what we saw in the 1960s in legal scholarship, socioeconomic and social science research findings, that it was possible to marry both moral obligation and the legal obligation to engage in activity that would maximize returns to shareholders. It is, of course, worth mentioning that the financial crisis of 2007 and the subsequent Great Recession initiated a search for better risk measures. And some experts have suggested that consideration of these environmental and social and government factors have the potential to improve risk assessment. Now, what's allowed by law, what's required by law? Proponents have argued that the true value of these ESG factors is more than their benefit to third parties in pursuit of social well-being. ESG factors are risk factors. Social well-being is a risk factor. It is important to note that any board that is doing its job and meeting its fiduciary duty needs to consider these factors. Now, my colleague, Professor Rob Sitkoff, in an article with his co-author, Professor Max Schatzenbach, recently explored the limits of ESG investing on a recent article published in the Stanford Law Review. They show that in the American context, ESG investing is permissible for a trustee of a pension, charity, or trust, subject to American trust fiduciary law when two conditions are met. First, the trustee reasonably concludes that the ESG investment program will benefit the beneficiary directly by improving risk-adjusted return. And second, that the trustee's exclusive motive for adopting the ESG investment program is to obtain this direct benefit. Professor Schatzenbach and Sitkoff emphasize that a particular ESG strategy will not necessarily satisfy a trustee's fiduciary duty, and that a trustee is never obligated to consider ESG factors despite their current popularity. Now, I think what's really important is to note that there's an ongoing debate about the requirements imposed on firms with respect to ESG factors, and Professor Sitkoff and Professor Schatzenbach's article, I think, illustrate some pathways forward for firms. But in the global setting, a group convened by the United Nations called the Principles for Responsible Investment, along with a growing and influential group of scholars and practitioners, have also taken the position that fiduciary principles require a trustee to use ESG factors. So beyond the American context, ESG factors have been viewed, at least in many jurisdictions, as a requirement, not a discretion. Now, when you think about the role of a firm, it is helpful to think of the umbrella term, these ESG factors, the social well-being, as having two distinct categories. There is, of course, investment for moral or ethical reasons, to address the needs, perhaps, of minority populations, to deal with the consequences of a global pandemic. But there are also, of course, the need to consider the collateral benefits that often flow as a result of these investment activities. It is crucial to note that once you have some sense of clarity, what is the risk return on considering the kind of consequences that silence on social well-being might have on the corporate form, then it makes easier the case that moral obligations to attend to one's neighbor, to be part of the fabric of a community in which a firm derives its profit, is as much a responsibility of the firm as the kind of categorical clarity that Schatzenbach and Sitkoff argue is important from a fiduciary perspective. Of course, ESG investing can be implemented by shareholder voting or other engagement with management in a manner that improves firm performance and therefore investment returns. In other words, it's not just corporate management or corporate governance, but shareholders themselves can think about and incorporate within the context of their shareholding opportunities to advance the case for corporate social justice and corporate social responsibilities. There is no question that corporate social responsibility and sustainability are areas of growing interest to the firm. In 2011, just under 20% of S&P 500 companies published a sustainability or CSR report. By 2013, that number had grown to over 72. But these activities remain ill-defined, lacking in objective measure. They're inconsistently reported. They can make efforts to reconcile these activities with shareholder value difficult. Today, more than 90% of the largest 250 American companies produce an annual corporate social responsibility report. The Harvard Business Review in 2018, there was an article published that indicated that Fortune Global 500 firms spend about $20 billion a year on CSR. They donate their products, they sell fair trade coffee, they sell conflict-free things, but really the impact of these have yet to penetrate the mainstream of the considerations that have come to light in view of our current situation. The killing of George Floyd by a white police officer was a driver of one of the largest protest movements in recent history. Corporations of all stripes, of all sizes, felt compelled to come out, to take a stand on the role of social justice and the importance of social justice. Many CEOs wrote blog posts, took to social media, pledged to spend more on social justice initiatives. The standard for corporate entities has simply risen when it comes to moral obligations. But is it any greater than the moral obligations that shareholders have, than the moral obligations that citizens have? The notion of corporate social justice reflects in some part the power of the firm. And as I said earlier in my opening comments, it is difficult today to find an individual corporation or entity making decisions sufficiently that takes into account the interests of a greater number of people. Corporate social responsibility is a self-regulated framework that operates outside of the legal system with little accountability except the accountability that comes from those who participate in the governance and the consumption of the goods that these firms produce. In the wake of the protests following the racial pandemic, particularly with firms standing in solidarity with the Black community, many corporations have found themselves under scrutiny for their own internal practices. It is the classic case of physician, heal thyself, that in order to have an impact in an age of social distress, corporate firms must not only reflect internally within their own structures the values that they espouse. It must be more than just building the brand. The firm must become the brand itself. But I hasten to add, not alone. It is important to note that the failure of social institutions affect the firm's ability to be the face and part of the execution of many of the social issues and the social concerns that agitate our society today. We've entered an age of reckoning on social media where it has become harder to ignore political topics, and firms that are silent find themselves at the mercy of the approbation of their consumers. It is important to note as I conclude the following things. Firms have the obligation, the responsibility, and most importantly, the opportunity not only to cultivate the values and to defend those values in the broader society for which there has been much cry about injustice, particularly in the age of COVID-19. It is clear that these injustices have come to the surface, these inequalities have come to the surface. But it is also important for social institutions to work in concert with firms to address the causes and the underlying structural challenges that we face as a society. There is no end to the studies that show the good working conditions are significant contributors to social welfare. There's no end to the studies that show that giving the average worker wages that are dignifying, that accommodating working mothers, all benefit not only our sense of right and wrong and benefit our sense of fairness, but that they also strengthen the moral virtue and the soul of the corporate form. It is time for a great reset. The role of the private sector in providing the social good is no longer just an external factor. It's no longer just an external constituency that must be addressed. It is now clear, increasingly so in the wake of these pandemics, that the firm and the well-being of the soul of the firm is both a measure of its own internal practice of the values of equality and justice that we treasure so greatly, but also its responsibility in holding our other institutions responsible to live up to the promises of democracy, because healthy markets, healthy firms, and healthy democracies require just and equitable outcomes, not only for some or a majority, but for all. Thank you so much.
Okay. I am going to briefly follow up on Professor Okediji's remarks. And in my remarks, I'm going to really touch on three things. I want to talk about tech firms in the information sector. I then want to talk about what should be the role of corporations. And I just want to highlight some really key themes in the address we just heard. And thirdly, I want to offer a few thoughts for moving forward. Now, Professor Okediji mentioned she wasn't going to talk about tech firms because I was. So I'm just going to highlight 3 or 4 points about tech firms that we should think about, because tech firms today are the largest corporations in the United States. So the 5 biggest corporations in the United States are all tech companies, and in many instances, those companies may have more power than most countries in the world. I don't know how many of you have been following the events at Facebook, where Facebook basically shut down in Australia because of a dispute about paying newspapers. But I think their move to do that highlights their power. And there have been a lot of discussions about Twitter excluding people, and that also highlights the power of tech companies today. It's not just that tech companies are the biggest companies in the world for the most part. Actually, if you look at the global biggest companies, I think the only non-tech company in the top 5 or 6 is Saudi Aramco. All of the other top companies are either US or Chinese technology companies. So we have a digital economy that has a lot of concentration. 1% of counties today account for 32.3% of GDP, even though those counties only have 26% of employed people and just under 22% of the population. So this means that the digital economy is not spread geographically in an even way. Now, COVID-19 has highlighted some of the concerns about the digital divide because we've seen a K-shaped recovery in that people that were doing well and who might be connected to the digital economy are doing better, and many other people are doing worse. So people have referred to that as a K-shaped recovery. Some things to emphasize is that we need to think about law and regulation in light of the many, especially in the digital economy sector, where we're seeing increasing concentration. And because that sector is such a big part of the economy, it's having broader economic effects. And what we're seeing during coronavirus also highlights the importance of the digital divide in defining outcomes for people. So one of the things I think we hopefully will see a focus on, both within how corporations think about things and how other institutions such as government think about things is how do we provide opportunities to lessen the digital divide, because I think coronavirus has highlighted the huge impact of the digital divide. In addition to the business roundtable that Professor Okediji mentioned, Larry Fink of BlackRock, in his annual letter to CEOs for at least the last 3 or 4 years, has emphasized the broader role of corporations, both with respect to ESG factors, as well as with respect to broader questions of the community. So I think as we're thinking about how corporations should interact in this post-coronavirus environment, I think we really need to maybe think especially about technology companies, because they have some special particular issues that I think we need to think about. Now, what should be the role of corporations in this post-pandemic universe? Corporations, I think, need to take a broad approach to societal questions, but we can't assume that corporations can or should alone solve these problems. The key question is what should be the role of corporations along with other institutions in this area. I want to highlight Professor Okediji's discussion of the idea of firms. Firms are really an abstraction, and they really reflect what we think firms should be as that has evolved over a period of time. So questions of leadership and values are of continuing importance. And when we think about firms as abstractions, they're abstractions whose role and function is shaped by laws, regulations, and societal expectations. I'm often reminded in corporations, sometimes business associations, I'll show students a film from the 1950s, and it's about the basic idea of a corporation. And the film is about a steel company. And when the film was filmed, obviously environmental issues weren't really on people's minds very much, because the factory is spewing out all kinds of noxious fumes. And students always note, like, why is this factory spewing out noxious fumes? And the thing we have a discussion about often is that reflects changing values. We're all much more conscious about environmental factors today and the corporation's role in potentially environmental pollution. So it's very noticeable and marked today, and that reflects changing values about pollution. Corporations are one of many institutions that need to consider the many, and that means a long-term consideration about what should be the role of corporations in society. I also want to highlight the role of funds that Professor Okediji talked about in her remarks. Funds have grown, all kinds of funds, private equity funds, hedge funds have grown markedly in the last 30 or 40 years in particular. And because they're powerful and important intermediaries, we need to look where they invest. And we need to look both in terms of ESG factors, but we also need to look at what kind of businesses they invest in. Morgan Stanley in 2018 did a really interesting report where they talked about what they referred to as a $1 trillion blind spot. And they basically said that if you look at what private equity and other types of investors invest in with respect to women-owned businesses and minority-owned businesses, they basically have an idea that these businesses have funding, but they don't actually fund them. So there's a sort of a discrepancy between what they think funding looks like and what they're actually doing. And they call that a $1 trillion blind spot, because they basically say you're leaving $1 trillion off the table because you're not actually looking more broadly at businesses. So if Morgan Stanley can see that, I think a lot of businesses could see that as well. Now, in conclusion, I want to talk about key points for moving forward. I think we need to think about basically encouraging firms to have a real robust commitment to internal diversity. And I point to the recent book by Pamela Newkirk, a journalism professor at NYU, a book called Diversity, Inc. And I think corporations and a lot of other institutions in our society have much work to do with respect to questions of diversity. And I really highlight technology companies, because technology companies need to have a future vision that extends to questions of diversity, which means innovating around how do we think about these issues. I think technology companies are actually behind other companies with respect to many questions of diversity. Certainly the gender statistics are pretty bad, and many of the statistics for people of color are also similarly not very good. So one question is, what do we measure and how we measure? And I think technology companies have a role to help us in thinking about how to innovate in this sector. We need to encourage corporations to have public commitments that actually grow out of internal commitments and don't just reflect branding. And last but not least, I think this highlights a point that Professor Okediji made in her remarks, everyone needs to have greater internal scrutiny about what they're doing, both firms and other institutions. And that entails measurement and also really being self-critical and thinking about where we are right now and where we need to be in the future. So I think to end, I would say that future vision is key. we have a future that can be an inclusive future that incorporates people who have been excluded and who have really suffered during the pandemics that we've experienced in the last year and more. And the question, I think corporations have an important role to play in thinking about innovation and thinking about how we reach that inclusive future. Thank you.
Thank you so much to both of our speakers for the wonderful remarks. At this point, we'll now turn to questions. I think one thing that I'd love to hear from both of you about, and this is related to a comment that both have touched on. So Professor Okediji had talked about ESG and SRI, and some of the social responsibility and investment measures are accountable to consumers and to governance, somewhat outside of the law at times. Also that the firm is oftentimes the one that has to diagnose its own problems. Looking at history, though, we see sometimes the role that academia can play in shaping how we think about firms. And so I'm wondering today, what roles you both think that the legal systems and also academia can play in shaping the role that we think the firm should play after witnessing some of the pandemics of the past year.
Professor Arewa, you want to start?
Okay, I can start. I think that academics need to, similarly, when we think about the future vision I talked about, I think academics have to have a vision that's broader in terms of how we think about firms and how we determine what we see as the key problems of concern. One of the things, returning to Pamela Newkirk's book, Diversity, Inc., one of the sectors she actually talked about was academia, and we don't actually do so well by most diversity measures, especially at the faculty level. So I think that's something that we need to scrutinize ourselves from within as well. But I think we need to consciously think about what are the broader social problems that exist and how academics can play a role in identifying and coming up with potential approaches to dealing with those problems. And I think that's a place we can go, and it's an important value within academia that I think we need to think about.
I would only add to what Professor Arewa has said. I think that she and I both mentioned the failure of other institutions. It's very easy to think about the firm and corporations as being at the forefront of this, and in many ways they are. Corporations affect every aspect of our lives as citizens, whether we work for them or whether we just consume their products. And one of the things that legal scholarship can and historically has done well is to really provide a critical lens for some of the assumptions that we often operate around. And I'll just give one example. In my field, intellectual property, patent power is a very significant tool in our rationale that someone who invents something new is entitled to recoup the costs of that innovation and to be rewarded for it. And that's all wonderful because it's an inducement to private investment and innovation. But the result of the quasi-monopoly that a patent offers, we see very clearly in access to medicines. We see very clearly in the inability of average folks to afford medications that are life-saving. We see in the decreased competition around innovation because the patent grant is so thick and the property rights so significant. And so it's quite startling how often in the academy we do take for granted the underlying assumptions about the rightness or the appropriateness of a particular regime. And it is the truth, as Professor Arewa has noted, that the lack of diversity, and not just diversity on ethnic grounds, but diversity of even intellectual thought, diversity in viewpoint becomes so critical in how we assess and evaluate the capacity of a legal regime to produce outcomes that are increasingly better for society as opposed to worse. And this is an area that lawyers and law schools in particular really need to pay attention to. There's a lot of window dressing when it comes to diversity and the corporate form. And we see this in every corporate entity, and I include within that institutions of education.
No, I thank you so much for sharing that. It's really, I think, keying in on something you highlighted there, Professor Okediji, that was also stated in Professor Riwa's comments, was the role. Professor Riwa, you talked a little bit about there's a lack of diversity within tech firms, but also that in this future vision where we have diversity in these different spaces of power, that tech firms can actually be part of the solution to addressing some of these issues. I'm wondering if you could speak a little bit more on that and talk about how maybe they can be a part of the solution going forward.
Well, I think part of the solution just starts with measurement. A big discussion about tech diversity started because in the mid 2000s, technology companies started to release their statistics about what their employees looked like in terms of diversity, gender diversity. And the gender statistics were truly startling in that female representation in the technology sector is shameful in terms of how few women there are and how few, and there seems to be, and these types of patterns tend to reproduce themselves. So I think just measuring things shows the value of it. And it also shows that you're paying attention to changing it. So that the measurement was part of the change. And we also realize that the situation is quite complex. So in Silicon Valley, representation varies by group. So there's very little. So African-American women, for instance, have close to 0% representation. You see higher representation among Asian men, but only when there's something called the bamboo ceiling. So once you get to a higher level, Asian representation goes way down. So that suggests that there are different problems that need to be addressed differently, but they all relate to lack of inclusion at some level. So the question is, you can't just look at people coming in, you have to look at all levels. I think you have to compare. Tech companies will always say it's a pipeline problem. That's measurable. In many respects, Google is below the pipeline numbers, for instance. Many of the tech firms are below what the pipeline numbers actually are. So I think we can use numbers. Companies are very good at measuring data. The place where they aren't very good at measuring data is when it comes to diversity. And I think that's very curious. That reflects values. It doesn't reflect that they can't measure it. It's just that we need to think about ways to incorporate that value and measure it and be critical in terms of the numbers that we see and basically say, well, this may be partly a pipeline problem, but pipeline problems can be addressed in particular ways. And if it's to the extent we're below pipeline, that it's not a pipeline problem entirely. It also reflects problems of an internal creation. And I think the Covington and Burling report on Uber, I think is anyone who's interested in technology companies should take a look at, because it basically shows how systematic internal policies and procedures and approaches instituted a kind of culture that was very exclusionary for many, many different kinds of people within Uber. And I think firms, that's not a long-term way for a firm to run. Firms have customers, they have all kinds of clients that look at things like that. And that kind of approach to Uber, I think that approach to diversity has been reflected in other aspects of Uber's operations. And if you look at a series of court cases and other disputes in the UK, for instance, I think that attitude has really hurt them from a business perspective. So I think we can make actually, and McKinsey has been doing this a long time, you can make an argument that diversity is critical to firm performance. A lack of diversity actually, firms that are less diverse actually do less well. So it shouldn't be a difficult situation. It's not a difficult business proposition, but overcoming social norms and assumptions can be very challenging. And I think that's where our core goal should be. And I think technology companies should be leading the way. So we need to think about, I as an academic, and trying to think about ways that we can encourage them to do that.
And of course, there's just the idea, diversity is not a destination. And we have a very narrow, and I think all of us are guilty of this. We have adopted and nourished a very narrow view of diversity. It is not a destination. And so it's not just achieving diversity, but actually nourishing it, sustaining it, so that our corporations and our schools and our businesses are thinking and reflecting the richness, the breadth of the people and the communities that it purports to serve. I think the real issue is that not only do we view diversity as this destination, we also view it as an inconvenience. And that inconvenience means that often firms are doing the least thing possible to tick the box. And so holding ourselves accountable internally is so crucial, as Professor Arewa has mentioned, to sustaining a culture that not only says, no, we recognize that we exist in a community that is diverse and in a community that is represented by people all sorts of socioeconomic backgrounds, and our response to these communities needs to be reflected in the way in which our corporate culture is unfolding. It cannot be a destination and it cannot be an inconvenience. It is a moral requirement.
Yeah, no, I think that's something that, specifically touching on, I feel like that is something that's so true, especially diversity being more of a tool to have these conversations and maybe hold people accountable to these values internally. I wanted to ask one last question before we conclude the event. And this ties into comments both of you have made, and also give you a chance to close out and leave some last thoughts with us. Both of you in your comments talked a little bit about the abstraction that corporations can provide, and that at the end of the day, it's a tool for these values to be brought, for the will of humans to actually be exercised. And so with these internal values, diversity can be thought of as a tool to try to help the values that are being propagated by these firms. At the same time, we see social movements that can also hold firms accountable. This ties a little bit to the first question, but I'm wondering, going forward, we have a conversation, for example, tomorrow with a growth fund from Google, who is planning on investing 100 million in Black-led startups and investment firms. To close out, I know I'm a little long-winded, but to close, I would love your parting thoughts on how firms can do more that's not just window dressing. What more can they do in taking their place in the social responsibility of our community that is more than window dressing?
So I would just say, I think this goes back to something that Professor Okediji said in her remarks. The question is, what kind of communities do we want to have in this society? If we want to have strong, robust communities where people have economic spending power, we need to think about being more inclusive. And I agree, we need to think about diversity more broadly. It's not just skin color and gender, it's also geographic regions. There are regions in this country that have been decimated by sort of the economic patterns in the last 20 years. I grew up in Ohio, and there are parts of Ohio that have just been devastated economically. So I think we need to think more broadly, but the real core question we need to ask is, who is in our community? And we need to think about the many as being part of the same community and take account of them in making decisions. I think if we have that broader vision, we will start to take actions in line with that broader vision. I don't think we have that vision now. And I think that's the key thing that's missing. And this is, if you look at Silicon Valley, in the midst of all that wealth, there are people that are living in their cars. San Francisco, to solve their homelessness problem, hired people to pick up human feces. That was the solution. I mean, that does not solve the fact that people don't have homes or bathrooms. So I think we need to think more broadly in thinking about what the problems are and how we solve them.
So I think these are really important, and what we need to begin to come back to is that there are moral underpinnings for every economic decision. And as a society, we don't like to talk about morals. We don't like to talk about moral accountability. And we don't like to talk about the cultivation of morals. It takes courage to run against the grain, to not follow the crowd. And firms are going to need to exhibit more courage. They're going to need to exhibit courage about what it is that they see wrong and why they believe it's wrong. They need to be willing to put their values up front and to be held accountable and to be held to their compliance. It's important for us to think about how we form the moral fabric of the corporation, because it is a reflection of the moral fabric of the nation. When people are comfortable with the ill treatment of others, when people are comfortable or silent while others are in such great lack and distress, when it's okay to simply say, it's my job to generate profit and leave social well-being to another government institution, or for the government institutions or agencies to say, well, it's our job to pass the laws, but the execution is left elsewhere. In other words, this moral delegation, this culture of moral delegation has done more to weaken the fabric of our social well-being than anything else that I can point to. And I think it is at the root of the Great Reset. We have to steer the market around the values that are vibrant and critical to making sure that everyone has the opportunity to be the best version of who God made them. There cannot be, and we should not be comfortable with laws, regulations, and firms alone. Each of us, in our consumption patterns, in our advocacy, in the things that we defend, the things that we propel forward, needs to ask, who is being affected by this and how? Because if there isn't a place that is being held accountable within society, there will be a gap somewhere. And at the moment, we have this still too strict distinction between public and private. And I think what Professor Arewa and I have been saying is that for an inclusive society, that sharp, that blunt of a distinction is really a luxury. We must begin to see the overlap between social well-being and the individual decisions we make as institutions, as firms, and as members of the public at large. So cultivating a sense of moral obligation and understanding how those moral values get tested and refined and strengthened is, I think, a critical part of the future, if we want a future in which we are thinking about one another in human terms.
Thank you so much. On behalf of the Harvard Association for Law and Business and our audience, I want to extend a huge thank you to Professor Okediji and Professor Arewa for joining us today and starting our symposium with this very, very important conversation. This is going to be extremely helpful to our audience going into our next discussion tomorrow with Jeremiah Gordon, where he talks about Google's efforts to invest $100 million in Black-led startups and investment firms. But until then, I wish everyone good health and a great rest of your day. Thank you so much.
Thank you.
Thank you, JV.